Well, a very pleasant good morning to, first of all, our Senior Minister, Kerrie Symmonds, and all of you
Mhm.
colleagues from the Ministry of Energy, Business Development, and Consumer Affairs, members of the Small Business Association, and colleagues all. Welcome to the Small Business Association's platform, where on a monthly basis we pause to have what we consider to be an information session addressing a topic of interest, an area that will undoubtedly affect the small business community and the business community in general. And we believe an area that will enhance the operations of our member firms. I want to thank you so much for your patience this morning as we awaited the minister's conclusion of an earlier session. We're very thankful that you're able to be with us this morning. Now, for those who may be new to our platform, the session is recorded. So in the event that you miss any aspect of it, fear not. You'll have the opportunity in a day or two to visit our YouTube channel as well as our website on the SBA TV portal, and you can watch this session at your leisure and pleasure. So fear not. In the event that you miss any aspect of it, it is recorded. And we've dubbed this session today a chat. So the Minister, yes, is going to make a short presentation, and we have a number of questions. Some of you have already sent in. So we'll take a look at these questions. And as usual, we'll invite you to pose any questions on the chat feature of this Zoom platform. Throughout the session, you are to keep your mics muted, your cameras off, and when we get to that Q&A, you'll get the opportunity to pose your questions in our chat feature. So welcome again and thanks so much, as I said, for your patience. With us 160 persons on at this time, we appreciate that you've taken the time out today, Wednesday, to be a part of our members' information session. So Barbados has now a Beneficial Ownership, Transparency and Register Act 2026. And a lot of people have been asking, but what does this new piece of legislation portend for my business? What should I know as a small firm, a sole proprietor, an incorporated entity? And we hope to address all of these queries today. But in the event that there is anyone who do not know our minister today, let me share with you briefly that Mr. Kerrie Symmonds is an attorney at law by profession and has served in Barbados's legislature for over 20 years, holding positions in both legislative houses. He was a cabinet minister between 2003 and 2008, serving as Minister of State in the Ministry of Foreign Affairs and Foreign Trade. And from 2013 to 2015, he served as leader of opposition business in Parliament. And since May 2018, he's held multiple key portfolios, including Minister of Tourism and International Transport and Minister of Foreign Affairs and Foreign Trade. And presently, Minister Symmonds serves as Senior Minister coordinating the productive sector and is the Minister of Energy, Business Development, and Consumer Affairs. So, no stranger to the small business sector, no stranger to the SBA's platform. It is our pleasure, therefore, to welcome Senior Minister Kerrie Symmonds to our webinar today as we address this topic, the Beneficial Ownership, Transparency, and Register Act. Minister, over to you
Um,
to share with us
good
your
morning.
thoughts.
Good morning to you, Lynette. Can you hear me clearly?
Yes, we can.
Okay,
Thanks.
fine. And permit me please to begin by apologizing to every single one of the 160 people online for the delay in my arrival here. It was through absolutely no fault of my own. It's just that a meeting chaired by the Prime Minister was at a very critical and delicate point, and it was impossible to leave until when we had crossed that particular issue. Um, Lynette, I want to just plunge in because in the interest of time, this can be a very difficult, perhaps very technical and esoteric issue this question of beneficial ownership interest for those who do not have a specialized interest in it and have not been following it closely. But I want to say that it is of critical importance to every single Barbadian business person, everybody who is involved in business in Barbados. And if I could start by way of an explanation for those who may not be fully comfortable with what it is all about, I would simply say that it is about transparency in business. The beneficial owner of a business is simply that real, living, flesh and blood human being who owns or controls a company. It is therefore not simply the name on the letterhead. It is not somebody who is trading as something else. It is the individual who ultimately, as they would say, is the actual beneficiary and ultimately has access to and controls the flow of the money. Now, for most businesses, let us be frank, this is a very straightforward matter. Miss Lynette Holder may be the owner of a hardware store in town, and therefore there's no challenge as to who is the beneficial owner because you own it by yourself. Alternatively, Mr. Kerrie Symmonds may have a joint venture with Miss Lynette Holder, and between the two of us, we have a variety store, and there's no challenge as to who owns that because between the two of us, we own it ourselves. But life is not always that straightforward, and quite frankly, we know that in law, I think that the case is called Salomon and Salomon. It is possible for, not that it is possible, the court has said that you are expected to lift the corporate veil in order to identify who the directors are. And sometimes you have to even go beyond the directors. And around the world, the reason why this is done is because it is necessary to understand that there are people who use legal constructs, businesses, companies incorporated, and having an individual life of their own because a company is literally a corporate person. It can trade in its own name. It can recruit people in its own name. It has liability for negligence in its own name. And that enables criminals to abuse the corporate structure in order to hide the fruits of their labor. And by abusing the corporate structures, what we found is that around the world, criminals have learned to shield themselves from scrutiny as they pursue certain illegal activities. Now, a company can, for example, be owned by a charitable institution, a charity or trust, and that charity or trust may own another company. And then you may have a more intricate network where such a set of structures are registered in one part of the world, but they own an enterprise which is also incorporated, but it is incorporated right here in Barbados. And so therefore, there is a maze of legal entities that you have to go through sometimes to find out who is the actual ultimate beneficial owner. And this, in turn, poses significant challenges for the regulatory authorities, those people who must manage international financial issues, because they ask the question, who is behind the money and who is ultimately the real beneficiary? And I think that in Parliament, when I piloted this piece of legislation, I used the example of some of the most famous of the criminal enterprises which we've had in Latin America and in the Caribbean. And that example will hold true today. There are many cartels which are led by a solitary individual. And the cartel may have, or the leader of the cartel may have many, many companies, sometimes hundreds of companies. After they've been arrested and you start to unravel the maze, you realize that one individual may have had 200-300 companies. And these companies all had their own individual directors. And in some cases, the directors were just straw owners. For example, the maid, the gardener, the mechanic. But none of them would have had what we would call executive authority. None of them would have had by themselves the capacity to be anything other than figureheads, which were being used as shields, really, to hide the paper trail from the financial authorities who may wish to drill down to find out what is at the root of this business, and does this enterprise really represent the ownings, the holdings of the criminal who is suspected of being involved in any particular type of endeavor. So in the legislation that we've just passed, that clause 2 of that legislation, I do have the the draft of that here. Clause 2 says that the beneficial owner is an individual who ultimately owns or controls through direct or indirect ownership to 20% of the shares or the voting rights or the partnership interests or other ownership interests. Or alternatively, is the person who is exercising control through other means, for example, contractual arrangements, through the ability to exercise veto rights, to appoint or to remove directors. And that individual is the individual who is defined as being the beneficial owner. So if you have 20% of shares in a company, then you are the beneficial owner. If you can control the voting rights or the partnership interests, etc., you are defined as the beneficial owner. And the legislation which we passed has really one central requirement. It is a requirement that is saying that Barbados is holding itself up to the world to be satisfactorily regulated, so that we will be always in a position to identify who is the ultimate beneficiary behind any particular form of enterprise that is incorporated in Barbados. Now, I think that I should say that we have broadened the net because there's always been some reference to beneficial ownership in the corporate laws and regulations of Barbados. But it's not enough now. And this is really where the issue is. It is now deemed by the international community by and large, and I'm going to focus a little bit on the international community and their relevance to us in this matter. It is now deemed to be unsatisfactory just to have the laws or to have the regulations or to even have the administrative practices. What is now required is to be able to demonstrate that they work effectively. And it is now required that we demonstrate that we can show the results of technical compliance. So the regulators will say to the ministry, show us the financial crimes that are being investigated and prosecuted in Barbados. And they will say, show us the proceeds of crime which have been confiscated in Barbados. We know that you have written laws, but the written laws have to also bring results by way of prosecution for the financing of terrorism, by way of prosecution and with regard to anti-money laundering, by way of prosecution of the proliferation of weapons of mass destruction, et cetera, et cetera. And this places a tremendous burden on local authorities, especially those of us in small island developing states like Barbados, because as I'm sure everybody it has crossed their mind during the last 2 minutes of what I just said, well, we ain't gotten a big lot of trafficking in arms in Barbados, and then the only terrorism that we know of is when a Cubana plane crash, and what weapons of mass destruction you're talking about, that does not happen down here, et cetera, et cetera. But the regulators internationally say that Barbados is part of the international community and that size is irrelevant. And therefore, we as a country have a duty to discharge, or we have a duty to discharge. And that duty essentially is that we must play our part in protecting the global financial system. Let me repeat that we have a duty to discharge, and that duty is that we play our part in protecting the global financial system. So while we may not have terrorists and while we may not have weapons of mass destruction, et cetera, we do know that we have to protect Barbados against it being used as a little nodule, a little piece in the puzzle of international financial linkages, which enable money to be funneled to support drug trafficking elsewhere, or enable money to be funneled to support the proliferation and acquisition of illegal weapons elsewhere, and so on. So the lens through which we are seen is a lens which requires us to be as accountable as possible to the international financial community of which we are a part. And if we are seen to be outside of that international financial community's regulations, then we run into another set of significant challenges. And I will go into them in some detail. Now, where we are really is that the legislation having been passed, it has been a product of the international regulatory agencies leaning on not only Barbados, but virtually on every country on planet Earth. And the Financial Action Task Force is perhaps the most important of these regulatory agencies in this regard. And they practice what I would really call a form of soft law. They issue strong recommendations. So they will make recommendations, and in our case, in Barbados's case, have been making recommendations from as far back as 2018, 2019, with regard to the need for us to introduce enhanced requirements in order to prevent the misuse of legal persons, which are just companies. Remember, I said a company is a corporate personality. So they want to have improved requirements so as to protect this country against the abuse of by corporate personalities for illicit purposes. They make it clear that they feel that the country has a duty to adopt comprehensive approaches to the beneficial ownership and transparency requirements. And this legislation that we're talking about is, in fact, the most comprehensive of approaches, because the legislation now captures not just what we would formerly have called, in previous times, we would formerly have referred to the international business community. And yes, we know that there's a raft of businesses in Barbados, probably about 30,000 companies. And we know that the vast majority of them are not dealing with transactions that amount in any given year to $10 million or $20 million, $30, $40 million. And in the past, these types of interventions, triggered as they are by the international financial authorities, would have focused primarily on those large companies. But where we are today, ladies and gentlemen, is that the broader requirements for beneficial ownership are now deemed to be it is necessary for them to be as comprehensive as possible. And therefore, there is no company or no enterprise which is considered to be too small to be relevant in this process. Because we know that there are those people, and we've had one or two cases here, and I obviously will not comment extensively on a matter that is now before the court. But let us say, for example, we've had in recent times, I think it was in January of this year, an ordinary fishing business, which would have had a vessel that was arrested, and it found, I think it was 33 or $34 million of cocaine on board the vessel. And similarly, in even more recent times, I think it was within the last couple of months, we've had a business person in Barbados and an associate of his who've been charged before the court for possession of nearly $2 million in illegal drugs. And there have been other cases of that nature. So we must not fall victim to having a Kadir mentality, where we say, "Oh, Kadir, don't humbug the small man." "Oh, Kadir, this can't really be about the smallest of the people. This is a big people issue," because we know that it is not beyond the reality of the world we live in for supposedly small players to be involved in a network that includes far larger players, but they themselves are playing a role in the criminal enterprise. And so the international authorities are insisting that there can be no room for sentiment and that there has to be a broad-based net which captures, yes, the micro, small, and medium enterprises of every country, and that the consequences for failing to harden our legislation so as to capture every business, whether large or small or medium or micro, the consequences can be fairly severe. And one simple example of those consequences is in the example which has been faced by companies in the Bahamas and in Belize, and one or two other countries of the Caribbean, where they have faced the consequence of the country now faces the consequence of de-risking and loss of your correspondent banking facility. Simply put, what does that mean? All of us who have to trade overseas, we are going to buy, let us say we are going to buy product from overseas. You move your money from Barbados through an international financial network, which has corresponding banks in the country where you wish to buy that product. If you lose your correspondent banking facilities, because the country Barbados is now deemed to be too high risk for banks to expose themselves to the consequences of an improperly regulated commercial sector, then what will happen is that all businesses in Barbados will suffer because we all together will lose the corresponding banking facilities. It doesn't only impact the business community, it then also impacts the average Barbadian in their own personal exercises in their average daily walks of life. Grand or granddad who is dependent on somebody in the United States or in England to send back a little bit of money every month so as to help him tide or her tide herself through these times cannot get the money because there's no correspondent banking facility. You have a child that you have at university overseas, you can't finance that child overseas because you can't get the money to move through the correspondent banking facility, and so on and so forth. So you are exposing yourself to the risk of financial exclusion. And as I said, this has been the sad tale that has impacted one or two other countries in the Caribbean because of their inability to move with sufficient haste and nimbleness to implement some of these recommendations which come from the external agencies. But beyond the external agencies and international regulators, we have to be true to ourselves. And we have to recognize, as I was just able to point out to you, that we do know we have cases here in Barbados which lead us to the inescapable conclusion that there is the movement of illicit firearms in this country, that there is the movement of weapons that we have to be able to bring a halt to, and that where there's illegal drugs and illegal weapons, it also means that there is money that is being illegally passed and therefore money that is laundered. So let us not ever believe that these things don't happen here to some extent. And the reason for the legislation is to nip it in the bud. Now, the good news is that while we have had to face the reality of what we know to be the circumstances in Barbados, and while we have had to deal with the very subtle and sometimes not so subtle pressures being brought by the international regulators, we have created this piece of legislation, the beneficial ownership legislation, which essentially does a few critical things. And I think the most important one is that it creates what I can only describe as a duty of care. So if I go back to the legislation, let me just pull it up here. I will find that clause 13 of the legislation that a corporate or trust service provider or any legal person, which is the company and its directors itself, shall take steps to identify each individual who is a beneficial owner and the means via which that beneficial owner exercises control. So the legislation at clause 13 is placing a direct responsibility on every business owner in Barbados to identify those people who are their beneficial owners. At clause 14, you have to discharge that duty via demonstration of the records or steps which have been taken, the records or steps which have been taken, or that there are records or steps that can in the future be taken with respect to identifying the beneficial ownership structure of the entity in question. And then they identify the various areas in which that, or the ways in which that can happen. So you can identify it by identifying who responds to the notices when they're sent out. If you are acting on behalf of a company, for example, you are a corporate or trust service provider, invariably those are the attorneys at law or the accountants who are doing that type of work. Then who are the people that respond to the notices? Who are the people who feature in the ownership charts of the company. Who are the people who are involved in the due diligence documents when you see the due diligence documents, et cetera, et cetera. So there's a duty to establish and maintain maintain the required particulars, and those particulars are at the registered office of the corporate and trust service provider. Now, I want to come to the part that perhaps is most relevant to this MSME sector, because this legislation has been specifically crafted, and I must tell you, I went out of my way in order to ensure that we could give this sector what can only be called special and differential treatment. I don't think that you will find a piece of legislation in Barbados that specifically is crafted in such a way as to exempt small, medium, and micro enterprises from the rigor and not the scrutiny, but the rigor and the requirements that larger businesses have, while at the same time, of course, requiring you to comply. So you are required to comply as part of this sector, but you are in many ways excluded from some of the rigor that other businesses must meet. So the bill creates a beneficial ownership unit, and that beneficial ownership unit will operate the beneficial ownership registry to which I just referred, and that registry is the repository of the beneficial ownership information. So there's a central beneficial ownership register. That register is a single, secure electronic record of the real people who own and control companies and similar entities in Barbados. Now, the beneficial ownership registry functions with the assistance. Glass of water, please. The beneficial ownership registry functions with the assistance of a business compliance team, and the legislation itself creates the business compliance team. So there's no if, and, but, or suppose about it. There must be a business compliance team. That team is loosely called BCOM. And the BCOM, or business compliance team, is set up to ensure that information entered into the beneficial ownership register is accurate. So the first exemption is the beneficial ownership register for micro, small, medium enterprises. You get the assistance of the business compliance team, and they assist you in ensuring that the information that is submitted is accurate. So you must be able to give them the information, because obviously they would not know with regard to every single company. And then they assist in making sure that the register is properly made up, the real owners are identified, the information is entered and updated and reconfirmed on an annual basis. Any changes in the beneficial ownership of a company must be notified and filed within 14 days of that change taking place. And we know that part of the history of this country is that changes will take place, but people never come back to the corporate registry. And so therefore, it is only in a time of crisis or in a time when you need the information urgently that you realize, oh Lord, but so-and-so was changed as a director and we never tell anybody about it, and so on and so forth. That collected information is going to be checked by the business compliance team, and they're authorized to verify the information. They're authorized to enforce the accuracy. And I want to emphasize that this is really an area where the fullest cooperation is required in everybody's interest, because faulty information does not protect either the company or the country. It protects no one. So what does this mean? The legislation uses the term domestic threshold companies. And simply a domestic threshold company is that company which is entitled now, for the first time in the law of Barbados, to how best should I put it? To minimize or benefit from the fact that we have minimized any burden on MSME enterprises. And this minimization of the burden on MSME enterprises is being done in three ways. First of all, we have simplified the filing process so that local companies and local societies with restricted liability, which earn less than $1 million a year, will file their information through the business compliance unit. Now, you don't have to. you may be a company, thank you very much. You may be a company that is earning less than $1 million and you still want to retain an attorney or whoever to do your business for you. That is entirely your affair. But if you are a small and micro business person, then all you need to do is to be able to say to the business compliance unit, these are the pieces of information that you need, and they do the work for you in terms of doing the filing, in terms of guiding you as to what additional information may be necessary, and where necessary to hold clinics with groups of you so as to review and ensure that the information being submitted and being filed or proposed to be filed is correct before it is entered into the register. There is no requirement to secure the assistance of a third-party service provider. So we have exempted you from that. The other thing we have done is to amend the fee structure or to design it in such a way as to ensure that small businesses and micro businesses will pay less than the larger and more complex entities. And I wish I could remember off the top of my head what the fee structure is, but I really do not. But I do know that there is that distinction. And then third, we are removing the paperwork requirement of annual returns being needed. It is more useful and more simple to just have confirmation of your beneficial ownership replace information, as that replaces essentially all of the information that is normally required in submission of annual returns. On the street, I have heard people say to me that they have had, on some occasion, without fully understanding how this thing works, a concern about privacy. Let me say to you that the government remains committed to the principle of balancing individuals' private interests with the requirements for transparency. And so private interests, as far as I'm concerned, and I did say this in Parliament, private interests in today's world is also safety interests, because we know neighboring Trinidad is an example. When people have an idea as to who got money or who don't have money, then sometimes the people who have money are subject to being targeted by criminal elements, as I have said just now, has happened in Trinidad on a number of occasions. Now, the register itself, therefore, is a private register. It is not going to be accessible to the general public. No competitor of any business will be able to access the business's information. No neighbor of yours can go and look up the information in order to malicious in your business. The beneficial ownership information is really there to be accessed by the tax authorities of this country, or alternatively, by counterpart regulators, as in regulators of other countries, regulators from other countries who are investigating financial crime, and they can access the beneficial ownership information in Barbados subject to safeguards which are going to be built into, or which have been built into the Act. So the information is there, as I said, for the tax authorities, for counterpart agencies under our treaty obligations, because we equally can access other people's information under treaty. And then, of course, it is accessible via court orders for the law enforcement authorities, who will be the police and so on, who would only be able to access it via court order, because you or the business you are operating has been implicated in crime. Now, this is not by any stretch of the imagination, colleagues, a speculative issue. As recently as maybe 2 months ago, I was approached by a foreign minister of a state who was raising with me the concern that there is a business person in Barbados who they know, and we have established, owns a number of businesses, but one of them is operating in a country which is under sanction. And the business itself is functioning in that country which is under sanction in such a way as to be colliding with the sanctions which are imposed in that country. It therefore means that that particular business operator has run afoul of the law, and the beneficial ownership issues now arise as to be able to trace what are the true holdings of that company and where that money is going and for what purpose it is being directed. So these are serious issues. And again, I use that example simply to say to you that it is not a question of government humbugging you and making life harder, but these are realistic challenges that come our way. Now, having said all of that, I think it is fair to say that we are at a very interested and delicate stage in this matter. Up until 2 months ago, we as a world were speaking with one voice. If you follow the international news carefully, you will realize that on the 11th of August, I think it was, the United States government rolled back its beneficial ownership reporting requirements for United States companies, what they call their domestic companies. They have, however, maintained beneficial ownership requirements for firms which are foreign to the United States. Those firms must comply with reporting requirements. So effectively, what the Donald Trump administration is saying is that this law will not apply to the United States enterprises functioning in the United States, but foreign enterprises in the United States must comply with beneficial ownership requirements. Now, this has created a severe compliance divergence between the United States and its international partners. We in Barbados are among the international partners. The United States has effectively dismantled its domestic database, while the European Union, for example, which is also another international partner is making its anti-money laundering framework even more robust than it currently is, so that we are at a stage now where European financial institutions, for example, can no longer cross-verify and can no longer cross-reference ultimate beneficial ownership data with the United States federal database. And this has created nodules or nodes of opaqueness. When I say opaque, as opposed to being transparent, opaque meaning that you can't see through it. And obviously, the node is the single point of intersection. So if you imagine an international system where country by country by country, we're all connected, sharing data with one another so as to make sure that illegal weapons which are being bought or sold on the black market are the proceeds of that crime can be tracked, and that the people who are committing those crimes can be traced, or where we are dealing with situations where weapons of mass destruction are being financed by the proceeds of those illegal firearms, et cetera, et cetera. And those complex corporate networks are being tracked from country to country. Once we come to a point like where you have a country as big as the United States that drops out, you have an opacity node where you cannot safely follow the trail any longer. And therefore, financial information about serious crime can be concealed from authorities. That is the operational challenge that now confronts us. I may, if I was criminally minded, create a shell company in a jurisdiction with a weak or non-existent reporting requirement, and therefore that shell company would now become my primary business. And I operate my business, my illegal business, through that shell company. When the regulators are asking who owns this company, the trail goes cold and stops dead because of the fact that the corporate framework, the regulatory framework does not require the beneficial ownership information to be shared. Now, were that to happen to Barbados, and I say this very candidly with you all, I have heard it being said here in this country, apparently in the interest of consumers, but I am unclear as to how it helps consumers, other than to encourage a consumer to believe that we are not living in a real world. We are not in danger of over-regulating. The truth of the matter is that if we do not comply with the regulations, as I just indicated to you, we can, as a small economy, face the disastrous consequences of losing our correspondent banking relationships. There is no bank that is going to function in Barbados if it is a country that is deemed to be non-compliant with international financial regulations. And therefore, as difficult as those regulatory frameworks sometimes become, we have a duty to comply with them if we are going to hold on to inclusivity in the international financial system. It is something that matters for the individual who wants to buy things on Amazon overseas, as simple as that. As I used the example before, want to be able to send children to school overseas, want to be able to make sure you finance the inputs to your business by purchases from overseas. But if we don't do these things, then we can lose the correspondent banking relationship, which is substantially consequential for any small enterprise. The truth of the matter is, as I said, there are a few countries in the Caribbean who are weathering that storm. Reality also is that the United States has taken a position where they, perhaps, and them alone in the world, can make this gamble. And that is that they are too big and too vital to the global economy for them to be subjected to sanction. And I guess the real question is who is going to sanction the United States for rolling back their beneficial ownership reporting requirements for their domestic companies? And I suspect the answer to that is at this point, nobody's going to sanction them. But they can do that which others cannot. And we have seen them do this also within the realm of the World Trade Organization, where they're determined that there's not going to be any third party country which is going to make decisions on their trading rights and trading obligations. And so therefore, they simply are not subscribing to the judicial function within the World Trade Organization. There are some countries which can do these things because of their scale and the size of their economy. Other countries like ours, however, and this is the grim reality, are so small and their economies are so tiny that they must comply. And that if they do not comply, then you run afoul of international regulators who can sanction you in a way that causes substantial discomfort economically. So that is really where we are. I think that the American situation has raised the question of reducing the trust in the international financial circumstances. It has certainly called into question the issue of the absolute confidence within which we can approach these matters. And it has reduced, obviously, global regulatory capacity. But again, while that is for them and big elephants in the jungle to work out, it is for us to make sure that it cannot be said of Barbados that we are playing footloose and we are being reckless with international financial obligations and to misunderstand the circumstances within which we live. And then, as you would say on the street, you hear the shout, we get penalized while others go scot-free. So, Dr. Holder, I don't know that there's more that I could usefully add. But that is really the substance of what I would share with you at this point.
Yeah. Thank you. Thank you so much, Senior Minister, for a rather comprehensive overview of the legislation and in particular the implications for us here as MSME sector and as an economy. I've taken particular note. You've confirmed that the playing field is not level.
Mm-mm,
The playing field is never level, it would appear.
it
So,
is not.
the small economies often have to comply with the rules. Otherwise, they are penalized. And so we appreciate that fact. I think sometimes the average citizen may not understand or appreciate that, but it is so true. We have to comply. Let's get to if you will, Minister, the conversation following that overview. Let me preface for those who may have joined us late. Maybe preface by saying that the session is recorded. Let me remind you again, the session is recorded, and we also have colleagues from the Business Compliance Division of the Ministry on the call. I see two of them there, and they have already begun, Minister, to answer some of the questions for us. So we really
Okay.
appreciate that. They've been looking at the questions coming in the chat, and they've been responding to some of them. And I want to mention as well, Minister, that they prepared what we call a frequently asked questions list for us. So we have over 40 questions, over 40 frequently asked questions that they've prepared for us with the attendant responses. And we are going to circulate this list of questions and obviously answers after the session is concluded so that, in the event that a person has a question that wasn't addressed they'll be able to refer to that document. So we want to thank the colleagues from the Business Compliance Division. Minister, a few quick things. First of all, you've underscored that this legislation is not applicable to sole proprietors. So let's get that out of the way because that's one of the questions. All right, it's not applicable to sole proprietors, not applicable to charities, but may very well be applicable to non-profit companies and those limited by guarantee. That is also a question. So maybe we can get your comment on that one. And then secondly, I'll ask, um, persons are asking, well, okay, well, does this abolish the domestic annual returns requirement? So maybe if you can begin with those two.
Well, I don't know that it actually abolishes the annual return requirement, but I think it certainly fulfills the it oh dear, how do I put it? It is a far more useful and simple confirmation of the well, let's say yes. It removes the paperwork requirement for the annual return because the filing of beneficial ownership information gives you a more comprehensive confirmation on an annual basis of all of the information that would otherwise have to be required or obtained in these types of matters.
Yeah.
Yeah. Um, I forget the first one
The
that
first
you
one
had
was about
asked
the
me.
nonprofit companies. So we know the sole traders are out, the
Mhm.
charities are out, but what about the nonprofit companies?
I do not think that the nonprofit companies are excluded from this.
Mhm. Right. Okay. So the nonprofit companies are represented in this, and I
Yeah.
think that's one of the questions in the FAQ. So we'll be able to share that a little later on. Someone is
I
asking,
be,
what? Sorry, go ahead, Vince.
I believe that if there is any doubt about it, that you would do well just to contact the business compliance unit because I don't want to, without having recently gone through that aspect of it in detail, I wouldn't want to mislead. But again, simply by reaching out to the business compliance unit, you would be able to get an answer to that as part of the frequently asked questions that come up.
Right. Okay. And the Become team, for those who may not know, is situated within the Business Barbados office in Warren. So this is actually an arm of Business Barbados, which was
Mhm,
formerly Kaipo.
mhm,
And they've actually started a process where they are invited MSMEs to come in and meet with the colleagues, meet with their team members in the Become team to start the process of registering. So, we send out the information to our stakeholders. If there's anyone who didn't have the opportunity to before, who missed that, I'm sure the Become team can facilitate that for you
mhm.
going forward.
Right.
So
I
Minister, what's the difference between ownership and control? Is there any difference in law or any difference that we need to appreciate between who controls and who owns?
well, I think the control determines the ownership. And
Mm-hmm.
so therefore, if I go back to the legislation at clause 2 of it is going to say to you that the individual who ultimately owns or controls is doing so through direct or indirect um, ownership of 20% of the shares or the voting rights or
Mm-hmm.
partnership interests or any other ownership interest. So effectively, you're exercising your control through ownership of those shares, or alternatively, your ability to influence contractual arrangements of the company, or your ability to influence the appointment or removal of directors. So there's also the question of influence, and with influence comes I would imagine the percentage of ownership that of shares that you have, the greater the influence you have over the business of the company,
Mm-hmm.
which is why for most parts of the world, it averages around 25%. We are at as low as 20%. But the key thing is you're saying that once people have more than 25% in Barbados, 20% of the benefit of the shares of a company, then you are deemed to be having sufficient influence as to be determined as being a controller, an
Right.
owner
Okay.
and controller.
Right. Now, I've taken note in my research that the act was recorded in the official gazette. What I'm querying, I think I see a question here too. What's the effective date of compliance?
I believe that that date of compliance is very shortly upon us. I, 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 I hazard a guess, but I think it is within the month of September. I do
September.
genuinely believe that that is the case. I wish I had that with me because it is not written into the legislation, but it is, yes, is it possible for the BCom team, any of them to speak on this? Or they're only doing what they're doing,
Yeah, but they can type
um,
it in. But
type it
I'll
in.
ask my team
Yeah.
if they can quickly make I think it is Sanjean that's there.
Yes, Sanjay
So
would be the perfect person.
yes, okay. So I'll
I
ask my
do
team
know that the
quickly.
act was
Hmm.
proclaimed on the 1st of September. I do know that. So I suspect it may have come into to effect from then, unless there was another date given.
Mm-hmm, mm-hmm. Okay. So while the team works on Sanjean, who may want to give a comment when she comes on, I'm sure Minister she may want to tell us of those preferential rates for small businesses. So we've taken note of that threshold,
But
that
but
$1 million threshold.
But
So we
trust
assume
me,
that they're special rates.
the rates are not that high in any event for any company. The truth of the matter is, it is really about facilitating the companies in their requirement now to be able to comply. I don't think any company really wanted to have to go through all of this, but given the reality of where we are in the world and our responsibility to do our business in a very judicious way and appropriate way, we have to make sure it is facilitated, and obviously the facilitation does come at some cost. So there will be a fee for some larger companies, but we have managed to make it a more reachable threshold, more comfortable threshold for your
Yeah.
association.
My the old folks used to say more palatable, You
More
want
palatable,
a more
correct,
palatable
correct,
fee for small firms.
correct, correct.
Is Sanjean just querying if Sanjean is on as yet that we can
But
facilitate.
as you
Okay.
would, as you would, let me just also say, as you would appreciate, if you were to hire a corporate trust service provider, you probably would be paying an attorney at law, charging you by the hour or whatever for the services of doing the filing. Effectively, what we have done is to say to the business compliance unit of the businesses registered as small, micro, medium businesses in Barbados, and you may have what, 10, 15,000 of them, treat to these as people who are coming to you as part of a constituency of members, and facilitate them as best as is possible with their filings. There is a very minimal fee for that service, but it certainly is not going to be paying an accountant or an attorney on a hourly basis. It's an
Mhm.
awkward position to put this minister in because I'm also responsible for that business, that type of business as well. So I don't want to appear to be
Right.
discriminating again.
Right. Okay. Understood. Sanjean, are you with us?
Yes, I'm here. Good afternoon,
Okay. Good
everyone.
afternoon. You go right ahead with your intervention.
Yes, so Minister was correct in his response. So the act will be proclaimed on September 1st, 2026, which is next Tuesday.
Oh, we don't have a lot of time then, Sanjean.
Well, there's time to get the information together because the current laws do already say that this information was to be kept at the registered office. So I think for small businesses, it will just be a matter of getting the identity documents together, the proof of address, and going to Become to have the filing, to have assistance with the actual filing of the information.
Yeah.
As you alluded to the fact that Become has already started to receive information from companies. So we just want to encourage companies to come forward for early onboarding. Um, so that we can get the information uploaded into the portal.
Okay.
Yeah.
Now I'll admit, colleagues, when I look at what's required, it is really not it's not too arduous. That's the truth. It's information that most firms may have already and should have already. It is really a matter now of meeting with that compliance team to provide the information and have it uploaded in the registry. As Minister using one of your favorite words, I use it all the time. That may be the humbug, you
Yeah.
know. That may be the humbug for a lot of people now
Yeah, yeah.
to pause what they're doing. Those who don't have the service provider, pause what they're doing to go now to become to provide that information. So is there any provision being made? How can we make this process simple for the average micro small firm who is actually out there hustling on a daily basis to make money and get their revenues for their business? How can we make that process simple?
Well, I think that, as I just indicated, I think you and Sanjin just echoed it too. You go into the business compliance unit. I do not know if Sanjin is doing it via appointments. Sanjin, you perhaps could guide me there because I'm not familiar with how you're doing it on a step-by-step basis every day. And I would imagine that you will, because people now know the 1st of September is that start date, you will get more and more people coming through the door. My feeling is, and I say this very cautiously because I don't want people to abuse what I'm going to say, but we have to be practical. The legislation comes into effect on the 1st of September. It does not mean that on the 2nd day of September, unless everybody has gone and made their information available on the register, that you are automatically going to be penalized. I think that we have to realize that there is a process and everybody's not going to get there on the 1st of September. But certainly it is necessary for people to act responsibly and to try to make this a first priority, so that my thinking is that you should reach out to BCom and let them be part of the conversation as to how you can be scheduled if you feel that you need their assistance. Sanjin, do you have a thought on that? Is she there? I can't.
Thank you, Minister. I'm here, but also
Mm.
with us in the room is an official from BCom, and he will respond to your question.
Okay.
Hi, yes, good morning all, good afternoon all. Okay, so yes, there is the opportunity for appointments to be set with the BCom team. At present, we're doing the walk-ins because obviously there are persons who may not have the time to stop and set up per se. So you can actually just come down to the team, and we do have a full team ready to facilitate the filing for you.
So what about those who may be off island, currently overseas, Minister or Sanjin, those beneficial owners who are currently overseas or off island? Any
Ye
provision for them?
Yes, there are provisions that are being made for our overseas clients as well. And we will deal with that as persons contact us. And we'll have those provisions shared with those persons directly.
Right. Okay. And an interesting query I think I'd asked earlier about the abolition of the annual filing, if that is to obtain now. And looking at the questions, I'm seeing a query here about filing from, let's say within the month of September, and if that firm will still be expected to file in December as they would have done their annual returns. I'm not sure if this person may have joined in late, so Minister, if you can give a comment to that, or Sanjin, who wants to take that one.
I will defer to Sanjin.
Mm.
Yes, thank you for the question. I think we tried to respond in the comments.
Okay.
But
Sorry.
so the response is simply that the annual return obligations that are outstanding before September 1st remain outstanding obligations. So once an entity, a company, is required before September 1st to file annual returns, you must continue to file that annual return, and all applicable penalties will also obtain.
All right. Okay. Thanks, Anjine. And I've taken note that you have been answering several of the questions. I mean, they were at one point I looked up, I think there were 20 something questions. So thank you so much for assisting with that, and especially the point about the grace period. And you have noted that there is a 90-day compliance period following the proclamation of the act. So we appreciate that, not 90 days. What the SBA will continue to do is work with the BCom team, the business compliance division in the ministry, to help sensitize and also to help members, to meet that obligation. I think the minister mentioned earlier the possibility of clinics and so on, because we obviously what is not practical is a mad rush of firms done at the Business Barbados office in Warrens. That's not practical over the next few months. So there must be that kind of, I'm hoping that kind of satellite office or a decentralization of the efforts in different geographical places that persons can that can go to, that may be considered convenient, that they can complete their registration and obviously their compliance with this piece of legislation.
Yeah,
Yeah,
I
go
think that
ahead.
the scheduling, in that regard, the scheduling is really also very important. And I really would want to underscore the importance of people not just going, but because you may go and find yourself in a line and then the frustration of waiting, et cetera, et cetera. But it is useful, I think, to schedule your time of arrival, and especially if you're going to need assistance with the filing, so that the team at BCom is able to better facilitate you.
Right. Okay. Great. Sanjeen, I'm not sure if you were able to give us the rates. I think I'm seeing someone asking again what are the rates in the chat.
So what I can tell you is that the rates have not yet been approved by
Okay.
cabinet, but there is the rate for the filing of beneficial ownership for small companies, domestic threshold companies, will indeed be more attractive than the rate for larger entities. So as Minister said, we have considered smaller companies and try to make the whole process less burdensome. What I want to add, though, at this point is that we will be putting a website out there with all the information that you will need for beneficial ownership and to help to facilitate the filings either through BCom or through a corporate and trust service provider. And we will let the public know where the information that they will need to get onto this website. So within the next couple days, we will have a website, a running website with all the relevant information.
Right. Okay. All right. Thank you. Thank you so much, Sanjeen and team and colleagues. If you've missed any aspect of the questioning, please revert to the chat. There are several questions there and responses from the business compliance team to those questions. And as I said before, we've already received a list of frequently asked questions, about 45 such questions with the attendant responses that we will send out to you in our email blast after the session, so that you can see what the frequently asked questions are, and the responses that have been provided by the ministry. Because as I look at the list here in the chat, there are actually all the questions that are on that list. All right. So in the event that you didn't quite capture the response and you need further information, it will be there in that list that we will send out to you momentarily. So we are out of time. We do keep these sessions, Minister Chris, 1 hour. And I think we've exhausted that, but understandably so. So, Minister, I'll ask you if you want to give any final words, any departing words before we conclude our session.
Only I would want to say to you that I'm not sure if any questions were raised on the question of the register, because I know that the one or two people had approached me personally, as I had indicated, in terms of the security of the data protection. That obviously will apply to data collected, and the register, as I said, is not going to be accessible to the general public. It is only accessible to the tax authorities of Barbados and to those other counterpart agencies and regulators who would be in the process of, under treaty obligation, working with us in trying to police any potential international or local crime.
Right. Okay, great. And as we say here for our webinar, that's a wrap. Ladies and gentlemen, let me thank you again for joining us for our monthly information session brought to you on our Zoom platform. We have had today Senior Minister, Minister of Energy, Business Development and Consumer Affairs, the Honorable Kerrie Symmonds with us, and members from the Business Compliance Division in the Ministry who were here to provide some support and additional information. We've seen all the questions in the chat and the responses provided by the team. So, you know, if you've missed any aspect of it, you can go there now quickly. Also, we've placed the link for our feedback on this session. As you know, after every session, we like to evaluate and get your input so we can prepare for other sessions to come. This webinar will conclude the webinar series for this quarter. We turn our attention next month to Small Business Week, and you're going to be receiving all the necessary information via the usual route, the email blasts, our social media postings, and the like. And we encourage you to come out and participate in all of the events planned for Small Business Week, September 13th to 18th. Again, we are going to zero in on the sector, zero in on what we need to take it forward from a policy perspective, education, finance, and all of the supporting areas. So come out and participate in Small Business Week, September 13th to 18th. And please note that the SBA will continue its partnership with the BCom team within the Business Barbados division and the business compliance unit at the ministry to make sure that we provide a platform for members to go and complete their filing so that we are compliant. If it's one thing we all know about Barbadians is that we are law-abiding citizens. Sometimes you don't like the legislation or you don't like what has to be, has to be done. But the truth is we comply. We buckle down and we comply. And that is a key aspect of the nature and the culture of the Barbadian, and long may that continue to be so. Minister, thank you so much. Thank you so
Thank
much.
you,
I know
Fran.
that today was a hectic one for you, but we really appreciate the hour that you were able to come and share with us today.
Thank you for having me, and I congratulate you on the initiative. Thank you very much.
Thank you too. And thanks to all of those who shared with us today, who spent a part of their Wednesday morning and afternoon with us. God bless you all. See you on the next occasion. Bye-bye for now.